What strategies, what techniques are there to protect assets for your spouse against long-term care costs? This is a much more salient concern. You know, if you look at the statistics, people that are over a certain age, over the age of 65 or 70, it's not a possibility statistically that they'll need care. It's a probability. Everybody is different. You know how statistics are. But if you are concerned about long-term care costs, well, you're right to be concerned. I mean, they can run from $2,000 to $3,000 a month for some extra help at home. To an adult family home might be $5,000 or $6,000, similar to an assisted living or memory care, $6,000, $7,000, talking per month. To a skilled nursing facility, which will be $10,000, $11,000, $12,000 per month. So you're right to be concerned about long-term care costs. And many of us have had experience with our loved ones, be it a grandparent, a parent, or a spouse, or friends. You know, we know that this happens, and this is something it just makes sense to plan for. Plan for long-term care costs. If you've got long-term care insurance, fantastic, keep it in place. Don't let it lapse. Majority of people don't have long-term care insurance. So what can we do? The most effective tool that we have as an estate planning and elder law attorneys is the type of a trust we put in your will. It's called an asset protection supplemental needs trust. Now, this kind of trust is specifically intended to protect money against long-term care costs. How does it work? Well, let's take the same scenario. Let's say $3 million, but you're in a situation where, you know, you are concerned that either you or your spouse, maybe you have a family history of dementia or Parkinson's or cardiovascular events, strokes. I mean, it goes on and on. You have $3 million, and let's say your house, you know, is worth $750,000 or $1 million. I mean, you have a pretty substantial estate. But you're really concerned about long-term care costs because there's been a diagnosis, or you expect that there might be, and you don't have long-term care insurance, for example. Even if you do, what would we do differently than that taxable estate planning? It's similar. We'd set it up with, you would each have a will, and in the will you have this asset protection supplemental needs trust. Now, how this trust is different is that it's called a discretionary trust. Whereas if you're just doing tax planning, you might have it what we call a standards trust for health, education, maintenance, and support, which is appropriate under certain circumstances. For example, you're not concerned about long-term care costs. The discretionary trust, why it is special, why it works, is that any money in that type of a trust isn't counted by the state, by Medicaid, as belonging to the surviving spouse for purposes of Medicaid long-term care benefits eligibility. And you might be saying, Lynn, why are we talking about this? We have $3 million. It's really a matter of simply doing some math. You know, Alzheimer's diagnoses can require care for 10 or 15 years. If you're looking at $150,000 a year over 10 years, that's 1.5 million. Add another 5 years to it, you know, you're over $2 million. This happens. Doesn't happen in everybody's case, but I'm just taking this scenario to show you why, even with an estate as large as 3 million, you might consider an asset protection trust. So here's the example. Clients are a couple, they're 75 and 80 years old. The 75-year-old wife has a diagnosis of Alzheimer's, and she is physically pretty robust. The husband is fairly frail. The husband dies first. Wife is not going to be able to stay in her home. She needs a memory care facility. What happens? Well, on his death, the first spouse to die, his $1.5 million goes into this Asset Protection Supplemental Needs Trust. Okay, what happens next? The surviving spouse, under Medicaid's rules, and I'll talk more about this at a different time, but if a surviving spouse is a single person, so they have to comply with Medicaid's rules for a single person for the state to pay for the person's care. Well, the state says that she can have $2,000 in countable resources, nothing. It's an impoverishment standard. The state also says she can have her house, and that won't interfere with eligibility. So this couple had $3 million. 1.5 goes into the trust. What doesn't go into the trust? Her house, which is worth $750, let's say. She's got $750,000 in her own name. Without doing anything more, she will need to spend down that money. There's many other strategies that exist, but let's say she does nothing more, she spends it all down. So when she is at $2,000, she will qualify for Medicaid, despite the fact that she has a house that's worth $750 and it's in her own name, and she's got $1.5 million in trust. State does not count the $1.5 million in the trust, and the state allows her to have a house worth $750,000. Our standards just changed as of July 1st of 2022 to increase the limit on home equity to over $900,000 that a single person can now have. So what's the outcome of all this? Well, after the husband dies, the wife needs to move into a care facility. If you're familiar with long-term care at all, you know that oftentimes memory care facilities have a 2 or 3 year private pay anyway, before they'll accept Medicaid, even if the person would otherwise qualify for Medicaid. So she uses her excess money. Maybe there's other strategies we do, but she pays for her private care. And then when she's down at $2,000, she applies for Medicaid. And then now the state is paying for her care at that very same facility. She does not move. She's been there for 2 to 3 years. She has spent down through various techniques to $2,000. She owns her house. She has $1.5 million in trust. She's Medicaid eligible for the rest of her life. She is Medicaid eligible, and the state will pay for the care for the rest of her life. This is one way to make sure that your surviving spouse never becomes impoverished. She's got a $1.5 million nest egg. She also has the house. What other strategies exist to preserve those assets? Subject for another day, but there are strategies. I use the $3 million just so that you could see that it's not just somebody that only has $300,000 or $500,000 combined estate. It's a strategy that, depending on your circumstances and the diagnosis that you're dealing with, you might consider an asset protection trust through a will, even with that size of an estate. Obviously, if the estate is worth less, if we have an $800,000 total estate, clearly that is a very appropriate circumstance to do the type of asset protection supplemental needs trust in your will. I'll just go through that example really quickly. Same facts, except for there's less money. Husband dies, $400,000 goes into a trust. Wife survives, she has a house worth $400,000. She's immediately eligible for Medicaid, immediately. Now, I just said that there's a 2 to 3 year private pay, how she's going to get through that. Lots of ways. She can sell the house when she's on Medicaid, lots of strategies to preserve assets there, or the money in this trust is there for her to pay through that private pay period. The outcome is the quality of care will be good. There's money to pay for it. The assets will be there for the rest of the surviving spouse's life. They'll never become impoverished despite Medicaid's rules, and Medicaid will pay for care once that private pay period for the facility has been met. And when the surviving spouse dies, the money, there will be money left to go where they wanted to go, to their kids, for example. So this from an estate planning and elder law perspective is something that is so important for me to share with you and for you to share with anybody you know that might, you might be aware of a couple that one of them has a diagnosis that is going to lead to long-term care, because so many people don't know about this. They think that there's no way to protect assets for their surviving spouse when they're gone. No, that's not true. There is this very effective planning technique, a will with an asset protection trust.